Good afternoon, everyone, and can I welcome everyone on behalf of Chambers to the Brick Court Chambers Annual Commercial Law Conference. We're delighted that so many of you have been able to come along this afternoon, and thank you very much for making the time available. The topic this afternoon is banking disputes, current trends and issues on the horizon. It is the first time that we've hosted a banking conference for some 6 years. The topic then was the collapse of Lehman 10 years on. And in the 6 years since, we've obviously seen a number of important new issues and developments that we will seek to be covering in the course of our 6 sessions, which cover the spectrum of the banking work that we undertake in Chambers. Each session is about 25 minutes, and within that session, there will be an opportunity for questions and any observations and participation, and we'd strongly welcome as much interactivity and participation as possible to make it a fully interactive session. On logistics, there will be a tea break just before 3 p.m. for about half an hour. And last but certainly not least, there will be drinks at about 5 o'clock. And now, since the topic is banking, we have chosen to begin today's sessions by marking the enormous contribution which Mark Hapgood QC made to banking law. As Richard and Jasbir will explain, Mark was the leading light at the banking bar until he passed away in 2020. And we are starting with some reflections on the part of Jasbir Dhillon and Richard Aikens. And without further ado, I will hand over to them.
Thank you very much, Fred. Jasbir and I have decided that in these reflections on Mark, whom we both knew, both as colleague and friend, we'd deal with 3 particular aspects. But there may be others of you who are present who have other things you'd like to mention about Mark, and we do encourage anybody who does want to say something to do so after Jasbir and I have spoken. First, Mark as an advocate. Second, Mark as a writer, particularly as editor of Paget. And lastly, but by no means least at all, Mark as a person. So I'm going to kick off. I first met Mark when he was my opponent in an application before Mr. Justice Sheen, who was then the Admiralty Judge in 1987. It was my application on behalf of shipowner defendants to dismiss a claim and set aside an arrest of a ship on the ground that the claim was not within the Admiralty jurisdiction of the High Court. I was leading Lionel Percy, now KC, but Mark was doing the case on his own for the plaintiffs, as they then were, claimants now. Admiralty jurisdiction was not exactly Mark's home ground, but he won. I was sure that Mr. Justice Sheen was wrong, but Mark's advocacy had obviously been much more impressive than mine. We appealed. Mark brought in Jonathan Sumption QC. Despite that, we won on appeal. Mark's clients appealed to the House of Lords. There, he was led by the redoubtable Stuart Boyd QC, but we won again. Not only was I impressed by Mark's advocacy and intelligence, but also his charm and his sense of humour. The encounter with me and with Jonathan Sumption led to Mark joining Brick Court from his old chambers, 45 Gray's Inn Square, where Michael Belloff QC was head. We'd actually developed a bit of a practice of pinching from them. We'd already taken Charles Hollander, and subsequently we took Neil Calver. Mark's practice in Brick Court took off. He worked very hard, but always had a lightness of touch. He took silk in 1994 after only 13-odd years in practice, and his practice as a QC also flourished quickly, particularly, as we all know, in banking and professional negligence cases where he became preeminent. The quality of his practice can be judged by the fact that he was involved in so many of the big trials, acting for banks or other professionals, particularly accountants. Celebrated cases included the one Elton John brought against Ernst & Young, his accountants, where Mark acted for Ernst & Young, who won, and the case brought by Equitable Life against their auditors, also Ernst & Young, which they also won. Accountancy Age, reporting on the Equitable Life case, described Mark as widely regarded as one of the best commercial lawyers of the age, which is not an overstatement. In that case, his co-leader was Jonathan Gazeman QC, or now KC, of 7 King's Bench Walk. They were a kind of good guy, bad guy team, Jonathan being the tough guy and Mark the emollient talker. I remember, when still at Brick Court in 1995, that he was the second silk, also acting for Ernst & Young in a case where I acted for the claimants, a Dutch reinsurance company called NRG. Mark was led by Christopher Simons, and the junior was Cyril Kinski, with whom Mark worked a great deal over the years. The case went on for a year. It was very heavy, technical, and eventually we lost against all 3 defendants. Mark, in contrast to his leader, retained a sense of humour and proportion throughout. Sadly, I never led Mark in a case in court, although we occasionally advised together. But when I went to the commercial court, I encountered Mark as advocate on a number of cases. There are 2 that I remember particularly well. The first was Springwell against J.P. Morgan. This was a case brought by the famous Greek shipowning family, Polemis, who alleged the bank had negligently advised them on investing their money and had lost a lot of money when the Russian currency collapsed in 1998. I was the judge who did all the interlocutory hearings prior to the trial before Mrs. Justice Gloucester. Mark represented the bank. His grip on the facts, as well as the procedure, was total. The litigation went on for 11 years in all and ended in victory for Mark's clients in the Court of Appeal, where we dismissed the appeal by Springwell against Mrs. Justice Gloucester's judgment in favour of the bank. One of the key battlegrounds in the run-up to the trial was the issue of expert reports. Mark's client wanted to keep out 4 expert reports that Springwell wished to adduce. There was a hearing before me to determine this, and I had to give a reserved judgment on it, accepting Mark's submissions and throwing out most of those expert reports. Mark's grip on all these expert issues and just why those reports wouldn't help the trial judge was so impressive. As was said in one report about his advocacy, when he appeared, the judge only wanted to listen to him, not the opponent. I was on the appeal court panel when Springwell appealed, and I gave the judgment of the court. There were 2 principal issues, one of fact and one of law. The factual one was what advice had actually been given. The legal one was whether the doctrine of contractual estoppel was good law and could be relied upon by the bank. We rejected the appeals on both points. Mark argued them all for the bank, and as I noted at the end of the judgment, was conspicuously patient with us in the many questions we asked on fact and legal issues. The last case I want to mention is Nataxis and Terra Firma, which was the last long trial I did in the commercial court. Mark led Jonathan David for Terra Firma. This was a case about securitization of debt, in which the claimants alleged that there was negligence or worse in the formulation of the mathematical model used to create the securitization instrument, and that had led to very large losses. This was very technical stuff on both securitization and how it worked, and the mathematics of the modelling and computer programming. Mark, as always, got to grips with it all, and he and his opponent, often his sparring partner in these cases, Mozambique QC as he now is, had to educate me on all of them. Mark showed conspicuous patience. We agreed on some new methods of dealing with such recondite material. Before the trial, I was given a teach-in by the teams of experts. It wasn't evidence, just learning. And during the expert evidence, I had the experts with me on the bench so they could talk to one another and I could ask questions of both at the same time. It worked in the sense that we got through all the evidence quite quickly. But then the case settled, just as counsel were sending me their closing submissions. But I have to admit, I was relieved.
As Richard has said, Mark was certainly one of the leading commercial advocates of his generation, and there's no doubt that he made a massive contribution to commercial law through his advocacy. And whilst, as I'll come on to, he was widely regarded as the doyen of the banking bar, Mark made a very significant contribution to a huge number of areas of commercial law, including professional negligence. Richard has mentioned two of his professional negligence cases that stand out, which is the defence of auditors from massive negligence claims brought by Elton John and Equitable Life. And I'd add a third, which is the claim that was brought by Barings Bank. But when one turns to banking law, Mark was quite simply the silk of choice for the leading banking cases of the 1990s and 2000s. And that was the case whether the banking case involved retail banking or wholesale banking. And it's easy to overlook the fact that a huge part of Mark's practice was advisory, where his wise counsel was frequently sought by any financial market participant who had a legal issue with a bet the company transaction. Richard has already mentioned Mark's victory for JP Morgan in the massive claim for damages brought by Springwell Navigation. The only thing I would add to that is the, I'm sure, apocryphal story that I heard after that Court of Appeal judgment, that JP Morgan was so pleased with Mark's advocacy and the result in Springwell that senior executives expressed a desire, no doubt tongue-in-cheek, to have all of their cases tried by Mark in the commercial court. And when I say all of their cases, I mean all of their cases worldwide. Mark was incredibly proud of his unique contribution to the law on the meaning of the ISDA Master Agreement. And the significance is not so much the amounts of money that were an issue in each of the individual cases that Mark argued, but perhaps because Lord Briggs has described the ISDA Master Agreement as the most widely used standard form financial contract in the world. And so Mark's unique contribution in advocacy, in arguing those cases, I think has an enduring impact on that most widely used standard form contract. Three cases I'd like to mention in that field. First, Mark was the successful lead advocate in Peregrine Fixed Income and Robinson, which was a decision of Mr. Justice Morbick, as he then was, in 2000, which established that the market quotation and loss measures under the 1992 form of the ISDA Master Agreement were intended to lead broadly to the same result, and that discrepancies between results achieved under those two methodologies was an indication that the result was not commercially reasonable. That case arose out of the 1998 Russian financial crisis, and unsurprisingly, the bankruptcy of Lehman Brothers led to a slew of cases on the ISDA-Master Agreement, and Mark was at the forefront of arguing those cases, including three that I'm going to alight on. First was Lomas and Firth Rixson, which was tried by Mr. Justice Briggs, as he then was, in 2010, and then heard by the Court of Appeal in 2012. And the case was bristling with knotty legal issues, but perhaps it's best known for determining that the payment obligation of the defaulting party under the ISDA-Master Agreement, which is subject to a continuing event of default, was suspended and was not extinguished. Second case is Anthracite and Lehman Brothers, which involved Mark leading me before Mr. Justice Briggs in 2011 as a trial of various issues of construction of the closeout provisions of the ISDA-Master Agreement, the 92 form, and the court determined that the loss measure under that agreement could be reasonably determined by the non-defaulting party using the replacement transaction quotation technique. And the last case I'd mention in this field is Enesarco versus Lehman Brothers, which involved Mark and myself, but this time as co-leaders in a trial before David Richards J, as he then was. And that case, I believe still, is the leading analysis of the calculation of loss under the 1992 form of the ISDA-Master Agreement. Mark's intellectual rigour, his penetrating analysis, and impeccable standards for written and oral advocacy were legendary. He was brilliant in argument on complex legal points in the landmark cases that Richard and I have mentioned, and many, many more. But as one of his instructing solicitors, who was a leading capital markets expert, highlighted, Mark's advocacy was so good it did raise a profound issue of procedural fairness, because the solicitor commented that when Mark was in court, I always felt we had an unfair advantage, as the judge only ever wanted to hear from Mark. Mark was equally adept as a trial advocate in some of the longest commercial court cases. His consummate skill as a cross-examiner, whether of Elton John or an expert in derivatives, was particularly striking because he admitted to me in discussion, in conversation, that he'd never conducted a cross-examination until he took silk. Well, one could never have told that from his performances that I observed. Mark loved the intellectual cut and thrust of the law and the courtroom, and he especially loved winning cases for his clients, which he invariably did, and even that was so when his opponents, including Richard, as he's mentioned, regarded Mark's cases as unwinnable. The next topic I wanted to make some very brief reflections on was Mark's contribution to banking law as an author. And as Richard has mentioned, in 1989, Mark accepted appointment as the editor of the leading general textbook on banking law, Paget's Law of Banking. And he continued in that role for 25 years, and while he did so, enhanced Mark's reputation as the leading banking lawyer of his generation. Mark took special pleasure in editing Paget because, in his words, I quote, "The law of banking has been, for me, a special fascination with its unique blend of common law, equity, and statute law." Richard and I would like to finish with our reflections on Mark as a human being, and perhaps I can hand over to Richard to begin on that.
Yes, thank you, Jasbir. Just a few words. What always struck me about Mark as a lawyer and an advocate was not just his intelligence and his capacity for hard work, but his patience, his equanimity, and his sense of humour. And this, I think, reflected very much the man that Mark was. There was often a smile there, even in the most difficult moments in court. And out of court, there was a ready laugh and a sense of fun and a sense of enjoyment of being with friends and colleagues as well. So really, Mark was not only one of the leading commercial silks of his age, but a most charming and friendly man with it. And that's the memory that I have of him, and we do miss him.
Mark was a man of great warmth, humanity, and generosity of spirit, and he had a very eccentric sense of fun. When I joined Brick Court Chambers in 1996, Mark had been a silk for 2 years, and even then, within those 2 years, Mark had such a formidable reputation that all of the pupils, all of my fellow pupils, were terrified at the prospect of being asked to produce any work for him. However, none of us had any need to fear. When my turn came to do some work for Mark as a pupil, he made it a point to give credit to my research when giving advice to his client in consultation. And this gave me a massive confidence boost as a fledgling barrister, but was absolutely typical of Mark, typical of his kindness, typical of his support for junior members of the profession. Working with Mark as I did over 20 years as pupil, junior barrister and co-leader was always an absolute pleasure. The cases were always incredibly demanding, but he was always incredibly kind, warm and supportive as a colleague, as a role model and a friend. As Mark's junior, you always knew you had a very limited amount of time to discuss your case before he would inevitably be dragged by one of the clerks away onto another matter. But if you ever needed Mark's advice or counsel as a mentor, as a friend, his patience and his time was literally limitless. Many members of the commercial bar, some of whom are here today, like me, owe Mark an immense debt of gratitude for that unstinting and generous support. While Mark had an extraordinarily fulfilled professional career, he also enjoyed a very full family and social life. Mark was incredibly proud of his wife, Arzu, and their 2 sons, Miles and James, and his 2 older daughters, Florence and Katie, from his first marriage to Linda. And he certainly always talked to me about his family in glowing terms and the fact that they gave him great happiness. The last time I saw Mark was in April 2019, when we had lunch in the hall at Gray's Inn, and we had a very enjoyable couple of hours gossiping and promised each other that we would dine again soon. It was immensely sad to hear of Mark's premature death at the age of 69 at the beginning of lockdown in 2020. Chambers and the bar have certainly been deprived of what would have been many further great accomplishments, and his family and his friends have lost a truly unique and wonderful man. I think that's all that Richard and I wanted to say in terms of our reflections, but we would very much invite anyone from the floor to give their own reflections on Mark.
If they'd like to.
Thank you, Paul. Just to say, I had the pleasure of being led by Mark on a number of occasions. When I first started in Chambers, he gave me the first outing in the Court of Appeal that I had on a very technical letter of credit case, and subsequently he proved to be equally at home in big Russian oligarch litigation. He was a towering intellect, He knew banking law inside out. He was a very inspirational and able advocate. But under all of that, he was an incredibly charming and capable leader. It was a pleasure to work alongside him and to see the skill with which he prepared for a case and brought his forensic analysis to bear. And his passing is a great loss to Chambers. And I would like to endorse the warm words that we've heard said in reflection of him here today.
Thank you, Roger.
Anybody else want to add anything? Well, we mustn't end this session gloomily, because Mark would have hated that. He did have a real sense of fun, and he enjoyed life. He enjoyed a good drink, and he enjoyed the company of friends. And he would want to finish this session, and before we go into the next one, with a smile on people's faces. So we must smile as we think of Mark and all he has achieved and all he's left us with, and think on the bright side of things as we go into the next session. Thank you all very much.
Well, good afternoon, everyone. Fred and myself are going to talk this afternoon about the recent Supreme Court decision in Phillips and Barclays Bank and the duties imposed by the common law on the paying bank. I'm going to ask Fred to speak first to examine the decision in Phillips itself, and I'll then consider some of the practical implications of the decision, both for banks and their customers.
Thanks, Roger, and thank you to the organisers, Fred and Richard. Thank you to you all for being here, even those for whom it's their birthday, which is extraordinary. Regrettable, perhaps, but you're very, very well done. So, Quincecare, the claimant is defrauded of about £400,000 by the chairman of the defendant. It's paid away, and of course it disappears into wherever these things disappear. And they sue the defendant, and they sue a guarantor, and they also, casting around for people who might have some deep pockets, they sue Barclays Bank. In the decision, Barclays Bank and Quincecare, Mr. Justice Steyn, as he then was, says that the claim against Barclays Bank should not be struck out. But it fails on the facts because there was no notice of the underlying fraud. Why does Mr. Justice Steyn say that this claim is arguable? There are three stages or three moves in his argument. He says, first of all, by hypothesis, or as he puts it, more highfalutin, ex hypothesi, there was an authorized instruction to pay out, and therefore a duty on the bank to pay out. Major premise. Then he says, well, that duty must bring with it the duty to comply with that duty with reasonable care, to take reasonable care in carrying it out. Therefore, stage 3, striking therefore, that includes a duty to consider whether to make the payment in the first place. And if you're on notice that there is a fraud, you shouldn't make the payment. There are some maybe unkind or impolite things you could say about that argument, so I'm going to limit myself to a technical piece of legal analysis and say, that's crackers as an analysis. Fighting words, why do I say that? Two things to point out. First of all, the argument is clearly invalid. If there is a duty to carry out the act in question, which is payment out, it is impossible to say that that duty being complied with reasonable care can somehow conjure up a duty not to comply with the duty in the first place. That's logically incoherent. Second, it's inconsistent with basic rules on implied terms. If there is an express duty to pay out, you can't imply a term, the consequence of which is that you should not pay out, because implied terms should not contradict the express terms of the contract. When a judge as great as Mr. Justice Steyn has said something that I think is so clearly wrong, it is worth asking why he said it. The first thing to say, I think, is the major premise was simply stipulated. As I said, Mr. Justice Steyn says it's true by hypothesis that there's a duty to pay out. Stipulation. And as we'll see, that's what the Supreme Court takes issue with in Philipp. The second point, which is a little more speculative, is that it's something about the era in which the decision was decided. The 1990s is the tail end of a rather freewheeling period in the law of tort, that its nadir is probably in the 70s in a decision called Ans and Merton. But there was a general view that the law of tort was a sort of instrument of social policy to reallocate losses when it was thought a bit unfair that someone had suffered one. The most striking example of how that line of thought was carried out was in New Zealand, where they just got rid of the law of tort and they had a system of social insurance. Ans and Merton said, essentially, whenever there is a loss that someone could, by doing something differently, have stopped happening, they were prima facie liable for that loss. Now, this is speculation, but those were the waters in which Mr. Justice Steyn swam, and they were the waters that he would have drunk when he was a law student. And so I think something of an explanation is that that was how he regarded the law. From the 90s or so, then there was something of a fight back on the law of tort. Lord Hoffman in Stoven and Wise is an obvious example, and in the last 10 years or so, the current Supreme Court has also restricted the law of tort to a more measured sense, except for in vicarious liability, which is a law unto itself. And that may explain why it is that the error is so clear to us, I think, today. But those are hypotheses. What happened then between Quincecare and Philipp and Barclays Bank? Almost nothing. There was only one decision where Quincecare was held to found a duty. Roger will talk about this, or say the same thing, but that's Singularis. That's perhaps best known for the sparsely reasoned decision of the Supreme Court on illegality. But at first instance and in the Court of Appeal, then Mrs. Justice Rose, as she then was in the Court of Appeal, held there was a breach of the Quincecare duty, which was why the illegality question arose. That was it. That was the only decision where it ever succeeded. And then along came the Philipp family. Now, the facts of the Philipp case are quite remarkable. The Philipps were defrauded out of a startling amount of money by someone who came to them and told them that they had to pay it away to bank accounts in the Middle East. And it's especially striking that they continued to pay out this money even after a police officer had come to their house and told them they were being defrauded. Eventually, the scales fell from their eyes and they realized they'd made a terrible mistake. So they cast around for someone to take the blame. And poor old Barclays Bank again got the writ. Now, the Philipps argument was that Barclays Bank were in breach of duty in complying with the payment instructions that the Philipps gave them to pay money out to the Middle East. It's a quite remarkable submission to make, but I suppose they had to make it. More remarkable still, the Court of Appeal agreed that that claim was arguable and did not strike the claim out. The Supreme Court demurred. Lord Leggett gave the judgment, and his essential argument is the one I've already suggested to you, which is that the assumption that there is a duty to pay out is incorrect in a Quincecare case. In a Quincecare case where there is, quote, liability, there is simply no proper instruction to pay out, because what you have is a person who is, suppose, seeking to extract money from the company for their own purposes. They clearly have no actual authority to do that because they're a crook. And if the bank knows that they're a crook, then they have no ostensible authority either. So there's simply no payment instruction. That's the basic move that Lord Legate makes, and as you might guess from the way I've presented this, I think that's the correct move to make. So that part of the claim was struck out. There was a separate claim which went forwards to trial. I don't know what happened about that, but that wasn't to do with the Quincecare duty. A couple of questions. First, if this decision was as crazy as I say it was, how did it last for so long? And I think that the answer is also one that I've suggested, which is that the banks never lost, pretty much, except for Singularis. So they never had to challenge this. The second possible explanation, or second thing to say, is that a striking feature of the oral argument in the Supreme Court in Philipp was that they did not make this argument that I've just presented to you. They didn't say Quincecare wrongly decided because the duty is all about agency, and so it clearly can't arise in a single payer case like Philipp, where there's no issue of agency. I don't know why they presented it in that way. They must have thought about the argument. It may be that they thought they'd look too greedy if they were to say there's simply no Quincecare duty. Or it may have been that they were wiser than perhaps I at the time realized. And it may not have been in their interests for them to get rid of this duty in this way. Roger will say more about that hypothesis in his talk. So what else is there to say? It's always a bit boring if the Supreme Court get it right, because there's not that much that you can say. So I'll try to say something that I think they did get wrong. Lord Legate, I think it's paragraph 70, does refer to there being a duty on the banks to take reasonable steps to investigate if they're on notice for fraud. And I think there is a real question whether talk of duty is correct. Now, a duty can only be meaningful in that sense if it means what's sometimes called a claim right, or the opposite of a claim right, that failure to comply with it gives rise to a claim for damages. And the question is whether there's any space for that sort of a claim once you do the analysis in Quincecare. Once you have concluded there's no authority, and the bank should know there's no authority, so they're not under a duty to pay out under the instruction, is there then a breach of duty if they fail to pay out? Or, sorry, if they purport to pay out by purporting to debit the account. But of course, there's no proper debit because there's never any authority given. Colour me sceptical. Lord Legate says there is, but I don't think that there should be space for those sorts of claims. I think the only claim should be one to say that the account should be, as it were, reconstituted, to say that there was never a debit from it. But I am, especially if you add Roger to the equation with Lord Legate, I think in a minority for that. So it may be that you don't want to give that criticism too much time of day. And with that, I'll hand over.
Thank you, Fred, for the helpful overview of the decision in Phillips and Barclays Bank. From the defendant bank's perspective, at first blush, it might be thought that the decision in Phillips was all good news. Going forward, in a two-party situation where no agent is involved, a Quincecare claim can no longer arise. That said, in the context of APP frauds, which was the fraud in issue in Quincecare, both the UK government and the regulators are about to intervene this week to ensure increased consumer protection. So although Quincecare claims will no longer lie against banks in this scenario, banks may find that they are liable as a result of changes to the regulatory codes and rules. However, in a commercial context, the two-party situation is clearly much more rare because agents usually will be involved. Thus, in cases involving corporate or government accounts, in practice, the payment instructions will always be given to the bank through agents, namely officers, employees, ministers, or civil servants. And it's these cases that are most likely to give rise to the high-value claims against the banks. And in this context, there is, perhaps surprisingly, from a claimant's perspective, quite a lot to be said in favour of the decision in Phillips. In particular, previously there was some judicial and academic hostility to the whole concept of the Quincecare duty of care. Judges, and in particular in my experience commercial court judges, were easily persuaded, as per Mr. Justice Staines' analysis, that the bank's primary duty was to pay out and to downplay the importance of the so-called conflicting duty not to pay when on notice of a fraud. There were also mutterings in some academic circles, most notably Professor Watts, the current editor of Bowstead and Reynolds on agency, against the whole concept of the Quincecare duty of care. Now, happily, the Supreme Court's decision in Phillips and Barclays Bank has put that debate to an end, and quite rightly in my view. If a bank has behaved unreasonably and paid out when on notice of a fraud, why should the bank not be liable to its customer, just like any other professional who fails to come up to professional standards? That said, as Mr. Justice Stain and Lord Leggatt were keen to emphasise, it will be a rare case where a bank has been found to have acted unreasonably, and the bank will often be entitled to assume that the payment instructions it receives are genuine and to give effect to them. A number of interesting issues remain, though, in the light of Lord Leggatt's illuminating judgment and the recasting of the Quincecare duty along agency lines. The first issue is, when will a bank be put on notice? Previously, this was notoriously hard to establish. More often than not, as Fred has said, the claim failed. The claim failed in Quincecare itself. Indeed, there was only one claim where it succeeded, Singularis and Daiwa. Now, the benefit of Lord Leggatt's analysis is that it allows one to draw on multiple cases, helpfully set out in Chapter 8 of Bowstead, where claims based on apparent authority have failed because the third party was on notice of the agent's fraud on his principal. And the main context for this in future will most likely be conflicts of interest. If the bank knows that the agent is paying money from his principal's account into the agent's own personal account, then that is a clear signal of potential fraud. That was what happened in the historic case of Midland Bank and Reckitt in 1933, which was referred to by Lord Leggatt in his judgment in Phillips. But clearly fraudsters are often a bit more sophisticated than that. What if the money is paid not directly into the agent's own personal account? What if a corporate entity is interposed? Suppose a government official instructs the government's bankers to pay money to an offshore corporate entity with an opaque beneficial ownership structure. Can the bank pay without making inquiries about the recipient's identity? Banks are used to doing KYC on their own customers, i.e. the paying party, during the client onboarding process. But banks do not normally carry out KYC on the recipient during the payment process. Normally, there would be no reason to do so, and the timeframes involved may mean that an investigation is impractical. Nonetheless, I would tentatively suggest that there are at least two circumstances where a bank might need to do so. First, where the name of the recipient suggests a link to the agent giving the payment instruction. For example, the payment is to an offshore company, which is named after the relevant government official or his or her spouse. The bank would then be on notice and should inquire. And second, where a recipient bank has already rejected the payment on money laundering grounds, and the agent then tries to follow up with a second payment instruction using a different recipient bank. The bank would then, in most cases, be on notice of a potential fraud and should inquire. More generally, it will be easier to establish liability by focusing on suspicious features of the transaction that were known to the bank, but which were not known to the bank's customer. It's in these scenarios where there is a clear information disparity between the bank and the customer that liability will most likely arise. The second issue going forward is causation. Now here, the decision in Phillips and Barclays Bank has undoubtedly made things easier for the claimant. Previously, a common line of defence taken by banks when faced with a Quincecare claim was this. The bank would say, there was no fraud. Alternatively, if there was a fraud, we were not on notice of it. Alternatively, if there was a fraud and we were on notice of it, any inquiries that we made would have been pointless because the fraudster was a plausible rogue and he would have found another way to extract the claimant's money. So the claim must fail on causation grounds. Now that argument, although often run by defendant banks, was always intrinsically unattractive. But as Lord Leggatt points out in Phillips, at paragraphs 96, the same argument does not work when the action is framed against the bank in terms of breach of mandate. If the agent is defrauding its principal, the agent has no actual authority. And if the bank is on notice that the agent is defrauding their principal, then the agent has no apparent authority either. So if the bank pays out, despite being on notice, it does so in breach of mandate, and it's simply not entitled to debit the customer's account. And it becomes irrelevant to consider hypothetically what would have happened had inquiries been made. The third issue is contributory negligence. Again, the decision in Phillips has actually made things easier for the claimant. A further line of defence, often taken by defendant banks facing a Quincecare claim, was that the loss was primarily due to the principal appointing and failing to control a rogue agent. And therefore, as between the bank and the principal, it was only right that the loss should be apportioned. In Singularis and Daiwa, the only claim which succeeded, the claim was reduced on the grounds that the claimant company, Singularis, was contributorily negligent, and in that case, the damages were reduced by 25%. But a defence of contributory negligence can only be brought under the 1945 Act in circumstances where the defendant owes a coextensive duty of care to the claimant in both contract and in tort. That's the case of Forsikringsvesta and Butcher. And if the defendant's liability in contract is strict, then there is no scope for the 1945 Act to apply. It follows that if, after Phillips, the claim is framed against the bank simply as a claim for breach of mandate rather than the breach of duty of care, a defence of contributory negligence cannot lie. Because if the bank has acted in breach of mandate, its liability to its customer is strict. See Lord Leggatt, paragraph 30 of Phillips, and the claim is therefore outside the scope of the 1945 Act. The fourth area, which will need to be explored in the future, is contracting out. Before Phillips, attempts had been made by defendant banks to argue that their standard terms and conditions meant that they had contracted out of their Quincecare duty of care. Now, in theory, banks can contract out of a duty of care, but it will take clear and unequivocal words before the courts will find that a customer has given up a valuable right or remedy that the common law would otherwise confer upon him. There's a long line of authority to that effect, and it was recently applied and confirmed by the Court of Appeal in the context of a Quincecare case that I was involved in, namely Federal Republic of Nigeria against JP Morgan. But the new agency analysis may now make it even harder for a bank to contract out of its liability to its customer. A third party, such as a bank, cannot normally, by its terms and conditions, alter the scope of the agent's actual authority. And even if the principal is asked to confirm the agent's authority in the broadest of terms to the bank, that may not be sufficient if the bank is actually on notice of the agent's fraud. Take the case of Midland Bank and Reckitt that I've already referred to. In that case, Sir Harold Reckitt had granted his solicitor, Lord Terrington, a power of attorney and had confirmed to the bank in a letter that the power of attorney was to apply without restriction. But even that language did not go far enough to protect the bank in circumstances where it was on notice that Lord Terrington was misappropriating Sir Harold's money. So stepping back, from a claimant's perspective, There is, in fact, much to be said in favour of the new juridical analysis which Lord Legate has provided in Phillips, and I strongly suspect that going forward, we are likely to see more claims against banks in which it is said that they've paid out when on notice of an agent's fraud. I don't know whether people had any questions for either Fred or myself on Quincecare. Yes, I could see somebody raising their hand.
Thank you. I do have a couple of points. I think we all know that the case of Philipp and Barclays was, the purpose of it was to extend the duty to individuals, and obviously that was a step too far. But the analysis about the competing duties, whether to pay or not to pay, clearly these analyses are relevant when the bank is on notice. And that is the single most important factor. Once the bank is on notice, there is no escape. You know, that is determined factor whether there will be a claim or not, really. And I agree with you that, you know, ultimately Philipp and Barclays helped the claimants. But I think, you know, the focus has to be, you know, what constitutes the notice. That is, you know, the most important factor here.
I agree with that. I think the notice issue has been the most difficult for claimants all along because the courts will readily recognise that paying banks have limited opportunities to make inquiries, and it will take quite extreme facts to put them on inquiry. But if they are put on inquiry, then the duty is there, and it is much harder now for banks to sidestep it. The liability is strict on the agency analysis.
Thank you. One of the significant strands of reasoning in Lord Legate's speech, after identifying the significant problem and the extent of the problem with respect to APP fraud, was the existence, I think at the time of the judgment, of what were then draft regulations addressing, to some extent, this problem. And Lord Legate, I think, relied on the relationship between the common law and statute law, where Parliament has decided to intervene. And that was, it seems to me, a significant strand of his reasoning as to why it was not appropriate for the common law to be intervening here, where Parliament has spoken. I think, certainly speaking for myself, and I'm hoping everyone else has all received emails recently from their banks notifying them that this regulatory framework addressing APP fraud is now in place. And I was wondering whether either of you had any thoughts about the adequacy of that regulatory regime in terms of addressing the mischief that Lord Legate did recognise arises in relation to APP fraud, and which, of course, the common law, unless you're on notice of fraud, is not going to step in.
I mean, I can give a short answer to that, which is no, I have no view. I didn't even read my bank's email when it came to me. So I'd be wasting your time if I were to say. I'd be interested in your views, but Roger may have others.
It's limited, isn't it? As I understand it, it's a change under the Financial Services Act to faster payments, and it only protects consumers or small enterprises or charities. And I think there's a financial cap as well, around 100,000 or possibly 80,000, similar to the general cap. It's really, as Lord Legate said, it's a question for the legislature to take into account the competing considerations. On the one hand, there is the need to protect consumers, the customers, the banks from increasingly sophisticated fraudsters. And there is a real and growing industry, unfortunately, of APP fraud. And when you read the facts of Philipp, they are about as stark and shocking as one could possibly imagine. On the other hand, there is the recognition that one can't put too high a burden on the banks. They receive huge numbers of orders to pay out on a regular basis. It becomes totally impractical if they are required to act as amateur detectives and to make inquiries in each of them, or for liability to be too readily imposed. And the result will be increased banking costs for all of us if liability is imposed too generally. So to answer your question, it's a difficult balance. I think time will tell whether Parliament has got it right. But I do agree with Lord Leggatt that it is supremely a question for legislation and not for the courts to try to juggle those difficult and complex social questions, particularly in the context of a contractual framework, where what you're really looking to do is to see how the parties have allocated risk between themselves, rather than to give wider social policy objectives the driving force.
I think the only other thing I'd say on it is that I just don't feel the pull at all. I would feel it if it was my money and I was defrauded. But I don't feel the pull at all for the Philipp family to think that there ought to be some kind of legal system that rises to their rescue to impose the loss on the bank. And that may just be a question of how hard-hearted you are. Maybe I'm just really sociopathic in this respect. But I don't see why it should be for the banks to have to do anything more than perhaps these limited things they do. Like say, are you really sure you want to send 500 grand to the Middle East? And if someone says, yeah, then well, good luck to them.
Any other questions? All right, I'll hand over
Thanks,
at that
guys.
point.
Afternoon, everybody. Laura and I are going to talk about the recent judgment in the Mozambique Tuna Bonds litigation, in which we were both involved, and just hopefully give some practical takeaways from the lessons learned in that litigation. So, in outline, the case concerned 3 projects that were sold to the Republic of Mozambique in 2013 and 2014. Certain entities in the Privinvest group of companies entered into 3 supply contracts with 3 SPVs set up by the Republic. Those supply contracts were ostensibly to provide services to meet the Republic's needs in securing and exploiting its territorial waters. They cost the Republic in the region of $2 billion and were funded from borrowing from Western banks, Credit Suisse and VTB. The loans were in the name of the SPVs, but the loans were then guaranteed by the state, by the Republic. So far, so good. Except for 2 things. First, what was delivered was not what Mozambique needed or could use, and the court concluded that the Republic was hustled to buy what it couldn't use properly and didn't need and wasn't prepared for. In consequence, the projects were unsustainable, the SPVs could not repay the loans, and the lenders called in the guarantees. That brings us to problem number 2, which is that the guarantees were secured by the payment of bribes. Mozambique alleged a large number of payments were bribes, but ultimately it focused on payments to the finance minister, Mr. Chang, it being he who executed the guarantees. The judge, Mr. Justice Knowles, also focused on Mr. Chang in his judgment. Mr. Chang was paid $7 million, and the judge found at paragraph 473 of his judgment that these were bribes. Mozambique had brought claims against the Privinvest defendants and its principal, Mr. Safa, in the tort of bribery, in dishonest assistance, and in conspiracy. It also brought claims against Credit Suisse, whom it said was on notice of and party to the bribery, given what the Republic said were myriad red flags of bribery surrounding the lending and the projects.
Mozambique was also on the receiving end of claims from other banks and syndicated lenders, which included my clients, who were three banks referred to in the proceedings as the ENYO parties because they were represented by ENYO. Those were BCP, UBA and BIM, along with VTB, who sought to enforce the guarantees that Mozambique had provided and to obtain repayment of the lending that they had advanced pursuant to those facility agreements. My clients and the other syndicated banks were all sophisticated lenders who had been brought into the transactions after the financing had been arranged and the terms had been agreed in negotiations by the lead banks. The ENYO parties advanced substantial sums of money, with the largest of them being advanced by BCP, which advanced $100 million. In each of the claims against the Republic, the position of the ENYO parties was a straightforward one. We said that whatever the answer to the underlying validity of the guarantee issue, in the light of the bribery of Mr. Chang or others, which was not something that we would get into, that was not something which impeded the ENYO parties from enforcing the guarantees, because they had known nothing of any wrongdoing and there was never any suggestion that they had. Rather, they had received and relied upon legal opinions from leading law firms as to the enforceability of the guarantees and had advanced funding on that basis. In those circumstances, we said, the law is clear that a party who does not have knowledge or notice of any wrongdoing is entitled to enforce its contractual rights. And so we brought claims under the guarantees in each of those three claims against the Republic. Mozambique resisted the syndicated lenders' claims on the basis that Minister Chang had not had actual authority to enter into the guarantees because of his bribery. And they also said that he had no ostensible authority that the banks and lenders could rely upon because there were red flags associated with the transaction which prevented the syndicated lenders from enforcing their rights under the guarantees. The Republic also raised a state immunity defence, which we won't have time to get into today, but which is specific to those proceedings. The proceedings were very extensive and hotly contested, and even leaving aside the final order and judgment, the proceedings generated over 230 orders of the court, over 60 rulings and judgments, and they even went to the Supreme Court in relation to the question of Section 9 claims under the Arbitration Act. Mr. Justice Knowles, as Richard has said, heard the trial over 13 weeks in the Michaelmas term of last year. And the claims with Credit Suisse and the other syndicated lenders, including two of my three clients, settled just before that trial. The claims brought by BTB and other syndicated lenders, including my third client, BCP, settled after the trial, but shortly before judgment was handed down. So that means that anyone going to the judgment looking for answers in relation to some of these banking issues may be sorely disappointed to find that the judge does not give definitive answers on any of the points that were in issue, because all of those claims were settled shortly before the judgment was handed down. However, it does go into some of the issues, and we'll deal with some of the points that come up that one can glean from the judgment in the course of this talk. The court had heard factual evidence from VTB and from my syndicated lender clients, as well as a wealth of expert evidence across over a dozen disciplines, which included banking practice. In practical terms, that means that Richard and I are now experts in fishing, and we know more than any Londoner reasonably should about how to catch a tuna. There's also a particular highlight from my perspective of the trial was the inclusion in the trial bundle by one of the fishing experts of the rip-roaring read, Tuna, A Love Story, which may or may not also be the working title for Mr. Justice Knowles' memoirs. We'll wait to see. Mr. Justice Knowles gave his judgment primarily in favour of the Republic in its claims against the Privinvest defendants on the 29th of July of this year, and the matter is still ongoing in terms of consequentials, and Privinvest has sought permission to appeal. So it's really a matter for watch this space and perhaps come back to Brick Court's next conference where we may have an update on these proceedings. We're going to turn now to the issue of red flags, which Richard's going to address first from Mozambique's perspective.
Yep. So when we talk about red flags in this context, what we mean is the facts and matters said by the Republic to put the banks and lenders on inquiry that Mr. Chang had been bribed and so lacked authority to enter into a sovereign guarantee. We don't have time to list all the red flags in this case. Someone who wasn't me totted them up, and the judge recorded that there were 94 red flags relied upon by Mozambique. The judge grouped them under 20 headings, grouping them even more tightly. They were essentially country-specific and sector-specific factors, party-specific factors, in particular the reputation of the contractors, Privinvest, and its principal, Mr. Safa, factors specific to the underlying projects and supply contracts, including their commerciality and the domestic legal process required to approve them, and then factors specific to the structure of the lending. Now, the first of those, the country and sector-specific factors, present a difficulty for a claimant because they are really just a reflection of the risk of doing business in a particular part of the world or in a particular sector. And this leads to the easy riposte that a claimant is really saying, if they're right, you can never really do business in emerging markets or connected to defence or public procurement. And this all reinforces a general point that a claimant must keep in mind, that a critical question when dealing with red flags is red flags of what? It's essential to tailor the red flags to the specific risk that it is alleged the banker should have investigated. So general red flags that suggest dodginess or some form of financial crime risk or unease in a general sense may be relevant to the level of scrutiny that a banker should give a transaction internally or to comply with its regulatory obligations. But they do not, without more, put a banker on notice of a specific fraud or specific corruption risk in a particular contract. Now, does that mean you shouldn't plead them? No, definitely not. Do include them. The courts routinely receive evidence that red flags are to be looked at holistically and cumulatively, and they're also relevant to assessing the bank's overall standard of diligence. So do include them, but don't put too much weight on them at the expense of transaction-specific factors. That in turn raises the question of a few red flags or many. Now, that will depend on the context, but the temptation will usually be for a claimant to plead lots, and there are risks to being over-inclusive. First, of course, not all red flags will have equal weight or brightness or whatever the right attribute of a flag is. But if your expert sees 200 red flags and considers absolutely everything needs to be investigated, they can quickly start to look unrealistic and detached from the commercial reality faced by frontline bankers day to day. Second, and related to this first point, if you're weak on particular red flags, they give the banks easy wins. You start to pick off a few red flags here and there, suddenly an overwhelming case with 90-odd red flags starts to look not so strong. Now, in any discussion of red flags, the role of expert evidence is very important, and Laura's going to talk a bit more about that shortly. But the key there really is the court wants to know from an objective standpoint what professional standards govern a banker's conduct when faced with the circumstances in issue, and what sort of inquiries should a banker have made. So as a claimant, you need to engage an expert or experts, plural, early, and ensure your pleaded case is one they support as a matter of industry standards and practice. You also need to give consideration early on to what sort of expert. Is it a compliance expert? Is it a frontline banking expert? Their commercial roles are different, and their roles vis-à-vis financial crime risks are different, albeit perhaps slightly less so than might initially meet the eye. But a claimant needs to think carefully about which bit of the bank it is alleging is on notice. Frequently will be multiple parts of it, but you need to make sure your experts hit the right target. So as part of that, where we're looking at something like project finance, what is it the claimant is saying the bank should have done in respect of assessing the underlying commerciality of the contracts? How does that fit within the day-to-day role and expertise of a banker? And that's something Laura's going to touch on, and I'll hand over to her to talk about red flags from the lender's perspective.
The way that the red flags issue played out, both in the pleadings and at trial in Mozambique, offers some interesting lessons, I think, for lenders in similar circumstances. As Richard has just been explaining, one of the key issues and challenges in formulating a red flag is pitching the flag at the right level of generality. A lender in the position of those of my clients would accept that some of the matters that were relied upon as red flags were indeed known to it. For example, that there is a generally recognised high risk of corruption in places like Mozambique, and that this was a project that involved SPVs. The same could be said for many of the transactions that take place in this part of the world, but not all of those will give rise to the suspicion of fraud that was being alleged in this case. One of the lender's first lines of attack in relation to the red flags argument was to argue that there's no general duty to inquire into an agent's authority, and that actually it was incumbent on the Republic to do more than simply pointing at generalised red flags, but to identify a specific reason why it says that the banks had reason to believe that Minister Chang was acting without authority in this case. That was, as a first hurdle, a very difficult one for them to surmount. The second line of defence was to argue that there must be a limit to the scope of inquiries that a commercial third party, such as a bank in this situation, must have to make in relation to ascertaining the authority of a counterparty's agent. The objective test is what inquiries would a reasonable bank have made at the relevant time in the specific circumstances of the transaction in question. Standing back from the matter, this was one of the points that was relied upon most heavily by the lenders, and I think it was a good one. We said, well, let's look at what actually happened here. The Republic, on its own case, knew nothing of the bribery of its own finance minister, yet it suggests that these third-party banks, some of whom were addressing this transaction from their desks in Lisbon or in London, ought to have identified for themselves that he was acting without authority. We said that didn't seem to make sense as a matter of practical reality. How could it be said that the Republic was not under the same level of knowledge as the lending banks? We were also fortified by the fact that dozens of lenders had undertaken due diligence in this matter, and having done that due diligence, had decided to go ahead and invest in total billions of dollars in this transaction. That practical reality, we said, was to be weighed very heavily against, for example, the finance expert who was put up by the Republic, who attested now that the transaction looked terribly suspicious and that he would never have invested in it. But I mustn't get too carried away with the merits of my client's position in that regard, because it is right to recognise that even though Mr. Justice Knowles didn't give judgment in relation to the bank's claims, he did give some indications in the judgment that was handed down about areas in which there might have been weakness in those arguments. There are portions of the judgment which are critical of some of the due diligence that was undertaken by the syndicated lenders. For example, he found that the banks had not been searching in terms of the IMF's position on the financial commitments that Mozambique was proposing to take on. And having heard from the experts that were called both by Mozambique and by the lenders, he found that very little attention had actually been paid to the underlying commerciality of the projects. And the lenders had been perhaps too easily comforted by the value and the availability of the sovereign guarantee that they had got from Mozambique. If nothing else, I think this litigation serves as a salutary lesson to lenders continuing to advance funds in this type of scenario, that even if one has the benefit of a sovereign guarantee, with the benefit of a leading law firm's opinion that that sovereign guarantee is valid, that is not the same thing as getting a cast-iron money-back guarantee, and there remains a very high degree of risk in relation to entering into this type of transaction. That brings us on to the next section of our talk, which is ratification. Mozambique was alleged by the other parties in the litigation, that's the banks and the Privinvest parties, to have ratified the guarantees that it had given, or perhaps because of its conduct, was said to have been subject to an estoppel, which now prevented Mozambique from denying the guarantee and its binding nature. In a nutshell, the issue in relation to ratification was that Mozambique had been on notice for some time as to the issues that it now relied upon as rendering the guarantees void. Indeed, investigations had begun by the Attorney General's office as far back as April 2015. But in parallel with those ongoing investigations, there were years of restructuring negotiations in respect of these debts in which Mozambique was actively involved, with the benefit of legal and restructuring advice, including from very well-regarded firms. It was the bank's position that in those negotiations, Mozambique had not qualified its position with any kind of reservation of rights. And therefore, they said that Mozambique had ratified its entry into the guarantees. There were issues at trial, largely superseded in the end by the settlements that were reached, as to whether there had been express ratification, whether there was implied ratification, at what stage ratification might be possible in circumstances where there is an ongoing investigation of that nature, and the applicable law of any issue in relation to ratification.
As Laura says, although largely superseded by the time of the judgment, ratification was a big issue at trial. The banks placed very significant weights on ratification. Ratification is essentially a sui generis notion that fills a practical need in validating the acts of agents who act outside of their authority. It's frequently used to cure minor defects in an agent's authority, but English law does not set any limiting factor in that respect, and there's no reason of principle why ratification cannot apply to a very serious defect in authority. Once ratified, the principle adopts the unauthorised act in its entirety and confers an authority that is equivalent to an antecedent authority. So for that reason, if you are a sovereign or any party that is alleged to have ratified, it's important to emphasise that the law demands that the principal has full knowledge of all the material circumstances in which the act was done. It's that requirement for full knowledge that was largely tried out, albeit ultimately undecided. There's also a prior point that does not seem to have been settled by any binding authority, which is, what is the governing law of the ratification issue? That can be hugely important in practical terms. The Republic said that Mozambican law governed the issue of ratification. If that was right, and the guarantees were null and void as a matter of Mozambican law, then it was common ground that they could not be ratified. So far as we could tell, no leading authority or leading textbook had properly engaged with the governing law of ratification. The two candidates really are the law of the agency relationship in issue, Mozambican law in this case, the law between the Republic and its minister, or the law of the contract, which was English law. Now, both have something to support it. My view is that the law of the agency relationship is the more compelling. Ratification is all about the relationship between agent and principal. It does not depend on any communication with the bank or with the party alleging ratification has taken place. You can ratify behind closed doors in a board decision or an executive act. It's not something that has to cross the line like an estoppel. So why, rhetorically, should a Mozambican official's acts as principal in a Mozambican law agency relationship with another Mozambican official be governed by anything other than Mozambican law? From the bank's perspective, however, it is of course seeking to enforce an English law contract, and there are similarities between the notion of ratification and the question of ostensible authority, which is a question that is unquestionably governed by English law as the putative law of the contract. Governing law appears to us, at least, to still be an undecided question, and maybe an important one for both sides of a guarantee dispute of this nature. Whatever the governing law, how does the sovereign or the guarantor protect itself? There's obviously a tension in trying to negotiate a commercial settlement while investigations are ongoing in respect of serious wrongdoing. Yeah. The judge noted in closing submission that it's not realistic for the state to have prefaced every communication with a lawyer's disclaimer or proviso that investigations are ongoing or anything of that nature. But there are real dangers in not doing so, not least the risk of having to litigate out these sorts of issues and take on the risk, still more being found to be on the wrong side of them.
For the lender's part, we came back to this issue through the prism of the central tension in Mozambique's case that I referred to in relation to red flags. How could it be, we said, that Mozambique did not have sufficient knowledge of the wrongdoing to ratify the transactions, but it said nevertheless that the banks had sufficient knowledge as to be on notice of that wrongdoing? One of the challenges we faced in this part of the case was the paucity of documents coming out of Mozambique, which would demonstrate its inner workings and its thinking and its awareness of the wrongdoing. We'll come back to the question of documents and witnesses in a moment as our final topic, but it was an issue that ultimately proved quite challenging for Mozambique in relation to ratification. On the one hand, there were a large number of public statements that Mozambique made over a period of years that the government stood behind these projects and recognised its obligations under the guarantees. Those statements might well have been made for political or commercial reasons, and one can easily understand why a sovereign in the position of Mozambique might wish to reassure the markets. But they were then seized on by the lenders as evidence of Mozambique's ratification of the transactions. Weighed against that, there was very little evidence coming out of Mozambique to make good its case was that despite these outward-facing statements, internally it had not adopted the transactions and it did not regard itself as bound by them. As Richard has explained, from Mozambique's perspective, it makes sense for a sovereign or the investigating party in this scenario to caveat any public-facing statement it makes by emphasising that its investigations are still ongoing and all negotiations are without prejudice and are not to be bound by the outcome of those negotiations. But what does one do with that in the position of a lender? I think the practical reality is that any lender who wants really to make any progress in seeking to restructure its investment or to recover any of the monies that it has advanced in these scenarios will have to have a degree of pragmatism. And that may entail accepting that the counterparty is not prepared to make uncaveated public statements outside the sanctum of privileged discussions.
The last topic we want to turn to is disclosure and witness evidence. As Laura has alluded to, Mozambique was quite heavily criticised and put under pressure throughout the litigation on its disclosure. There were numerous CMCs and a number of reported judgments on the topics, and it was a key issue where the other parties joined forces against Mozambique. Now, there are huge logistical challenges in disclosure for a sovereign, and that's particularly so in emerging economies that may not have record-keeping practices that are similar to those we might see in this jurisdiction or in a large corporate such as the banks. That may involve more use of paper documents which are warehoused or archived. It may also involve less use of institutional email as compared to personal email. There are a number of lessons to take from the disclosure experience in the Mozambique case. I'm going to touch on 3 of them. The first really is a reflection of the logistical challenges and the length of time that a corruption case can take to be commenced in the first place and then get to disclosure. That is that it's really imperative that the process of preserving documents is begun immediately, but that gathering documents begins long before the first CMC, because disclosure in these cases is just going to take a very long time, and you have to get out ahead of it. Second, the court repeatedly emphasised the importance of the Republic's solicitors in supervising the disclosure process. To that end, Peters & Peters had a significant physical presence in Maputo, which was something that was highly relevant to the court when it came to assessing the overall validity of the Republic's exercise. But ensuring proper oversight and involvement in the process, absolutely as far as possible in every stage, is vital. Third, it's important to think early about control of documents for the purposes of the CPR. A particularly important issue arose as regards control of work-related emails sent via personal email addresses from government officials. That led to a contested dispute where the court received evidence as to the applicable Mozambican rules and practice, and it effectively concluded that the widespread practice of using personal emails for work purposes, along with obligations on officials to effectively physically archive their work, permitted a conclusion that there was practical control by the Republic over the personal devices and personal documents, personal email accounts of its officials. And that was found to give control for the purposes of the CPR, whatever the position as regards Mozambique's legal rights and legal ability to compel its officials to turn over documents, which the court didn't decide. Now, these cases are all going to turn on their own facts, but the point to emphasise is investigate these matters, these sorts of matters, very early on, so as to put forward the strongest position possible as to why particular repositories are or are not available. The court is going to be sceptical of suggestions that state-related documents are not within the state's control. So if you're going to make that case, you need to flesh out why from the earliest possible opportunity.
On the other side of the courtroom, I think it's fair to say that the issue of disclosure was an immense frustration, and particularly for the poor solicitors who were acting on a day-to-day basis for the lending banks and for Privinvest, many of whom spent hours and weeks and days of their lives producing schedules of failings in the Republic's disclosure and attending CMC after CMC in relation to what seemed to us to be very painstakingly slow progress on that issue. In terms of the wider lessons that may happen, that may be of use in other scenarios where a litigant is faced with a counterparty making such slow progress in complying with its disclosure obligations and perhaps no real hope of ever getting meaningful disclosure out of them. And the 2 points that we've identified are these. First of all, an application was made for strikeout of Mozambique's claims, which was the nuclear option. That was on the basis that Mozambique had not properly complied with its disclosure obligations and had jeopardised any possibility of a fair trial. After months of disclosure discussions and CMCs on the topic, the application was made and then was dismissed in July of last year before the trial was due to commence in October. Mr. Justice Knoll addressed that application in paragraph 408 of the trial judgment, noting that he had held that at trial he would still be open to criticisms of the Republic's disclosure and that a calibrated response would be available to him then that might not have been available at that interlocutory stage. The strikeout application was renewed at trial, in particular by the Privinvest parties, but Mr. Justice Knowles concluded at paragraph 409 of the judgment that a fair trial had been possible despite the criticisms that had been advanced and that he found in certain circumstances were made out against Mozambique. He found there had not been an abusive process and that required strikeout of the claims, and he went on to draw some adverse inferences. That was the less nuclear option that the opposing parties adopted against Mozambique, which was to say that even if the claims the claims were not struck out, adverse inferences should be drawn against Mozambique for its failure to produce relevant documents and its failure to call witnesses who might have been able to shed some light on these matters from Mozambique's perspective. That more moderate approach found greater favour with the court, and the judge held at paragraph 412 that he would draw a number of inferences against Mozambique. One question arising from those conclusions, and you can go to the judgment to see exactly what it was that the judge was prepared to infer against Mozambique, is how one should pitch an inference that the court is asked to make in circumstances such as this. The judge recorded that he had been asked to make a number of inferences, some of which were very wide-ranging, by some of the lending parties who had suggested perhaps that he might be able to go further and find, for example, a conspiracy between the current president, Nyusi, and other high-ranking officials within Mozambique. The lesson from this portion of the judgment, I think, is to consider which inferences you need in order to make good your case and which ones are merely nice to have or incidental. And I think it's instructive to look at the approach that Knowles has taken, which was just to go to exactly the points that were essential in terms of resolving the key issues between the parties, and not to go further and make some of the more wild accusations into a finding of inference against Mozambique. I'm afraid I think that brings us to the end of our slot for this particular talk, but if you have questions, we'll be happy to take one now, or you can come and find us, because I think we're shortly due to break for tea. There's one question at the back.
I've got a question on this issue of the governing law of ratification. And I appreciate it wasn't dealt with by the judge, but as I'm interested in conflict of laws and involved with Dicey, it interests me. Presumably, because it was before an English court, English conflicts of law rules had to be applied by the court. So is this something that comes within Rome I or not? Because just reminding myself quickly, having had a look at it, it isn't obvious that it comes within its scope, but it's also not obvious that it comes within any of the exceptions that are in Article 1(2). So what was the approach of the parties, and what do you think would have been the approach of the court if it had had to deal with it?
Well, I think so far as friendly fire goes, that's a very unfair question. In all honesty, I can't remember the route to which the question itself was put before the court, whether that was through the prism of Rome I, or it was addressed... sorry, I missed that, Richard.
Was it Rome I or common law?
I think it was addressed on the basis of the common law rather than through Rome I. I certainly don't remember the parties arguing about this. The banks were obviously very keen to push forward the putative law of the contract as being the most obvious answer, and as I think I alluded to, that was really grounded in the basis that it was akin to ostensible authority. And the real problem with that is the difference with ratification and ostensible authority as to where the relevant relationship is to be found. Ostensible authority is all about the relationship between the representing party and the contractual counterparty. What have they received? What have they been told? What do they know? Now, that relationship is completely different from the relationship between the principal and agent, which is where you find ratification. It's that relationship which governs, which is a way of saying I don't really know the answer to your question, and I wish you'd come and find me at tea.
I think on a practical level, sorry, Richard, would you like to reply? I was just going to say that on a practical level, I think it's quite important to try to suss out any possible contenders for foreign law to apply quite early on in a dispute of this nature, because it's actually quite surprising. It was quite a surprising outcome that Mozambique does not recognise ratification as a doctrine, and that it does lead to a slightly surprising result under Mozambican law, which would not have been the case under English law. As Richard says, we were arguing heavily for English law to apply, and obviously English law recognises the doctrine of ratification, and it was an oddity of Mozambican law that it didn't. So on a practical level, faced with a similar scenario, it's obviously worth identifying the possible contenders for foreign law that might apply in these circumstances, and identifying whether there may be any material benefit for then launching a full-blown argument in favour of that scheme of law.
Yeah, I think that the stark disparity arose from the fact that Mozambican law doesn't allow ratification of something that is null and void. It's null and void ab initio, that's it. There's no resurrecting it.
And that was common ground between the...
And that was common ground. If we got to that bit of the analysis, if the guarantees were null and void under Mozambican law, and this question was governed by Mozambican law, the one of ratification, that was game over.
Great, thank you very much.
Yeah, I think it falls to me to say it's time for tea downstairs. Thank you.